Court is in session at cause number 327-774. Case of style of State of Texas versus Matthew Cord Marlin. We have Mr. Matthew Cord Marlin, who is appearing in court. Mr. Marlin, is that your full name?
Yes, sir.
Okay. Mr. Marlin, how are you doing?
Good. How about yourself?
I'm doing fine. Thanks for asking. Mr. Marlin, you're here represented you're represented by Attorney James Macon. However, standing in for Attorney James Macon is Attorney Joel Vasquez. Mr. Marlin, does Mr. Vasquez have your permission to stand in for Mr. Macon in this case?
He does, Your Honor.
Okay. And the state is represented by Attorney Daniel Boyd, is that correct?
Yes, Your Honor.
Okay. Now, Mr. Vasquez, I have before me a motion, and it's titled Motion for Return of Firearm, that was filed by Attorney Macon on October 19 of 2021. Mr. Vasquez, would you like to proceed?
Yes, Your Honor. Mr. Marlin has been in contact with DPS, with Officer Pena and Officer Hargrove about the return of his weapon. And he pled, I think the court just said in April of 2021. They've been in contact with him by mail and have gone back and forth about the weapon since July. So technically, we're outside the 61 days of the time that the court the weapon could have been destroyed or sold at auction or what have you. We're late in requesting it by statute, but they're waiting if the court will sign an order. Mr. David told Mr. Marlin if he took the order and took it down to DPS, they would return the weapon to him.
Okay, well, I think the motion, it cites Article 18.19 of the 18.19D
Yes, Your
of
Honor.
the Texas Code of Criminal Procedure.
Yes, sir.
And reading that section, it states that a person either convicted or receiving deferred adjudication under Chapter 46. And just for the record, Mr. Marlin received deferred adjudicated probation for a unlawfully carrying a weapon, which is under Chapter 46. And he received that on he received deferred adjudicated probation on April 21st of 2021. And it states here that a person either convicted or receiving deferred adjudication under Chapter 46 of Texas Penal Code is entitled to the weapon seized upon request to the court in which the person was convicted or placed on deferred adjudication. However, the court entering the judgment shall order the weapon destroyed, sold at public sale by the law enforcement agency holding the weapon or by an auctioneer licensed under Chapter 1802 of the Occupational Code or forfeited to the state for use by the law enforcement agency holding the weapon or by a county forensic laboratory designed by the court if, one, the person does not request the weapon before the 61st day after the date of the judgment of conviction or order placing the person on deferred adjudication. Two, the person has been previously convicted under Chapter 46 Penal Code. Three, the weapon is one defined as a prohibited weapon under under chapter 46 penal code. 4, the offense for which the person is convicted or receives deferred adjudication was committed in or on the premises of a playground, school, video arcade facility, or youth center, as those terms are defined by section 481.3, 481.134 Health and Safety Code, or 5, the court determines based on the prior criminal history of the defendant or based on the circumstances surrounding the commission of the offense that the possession of the seized weapon would pose a threat to the community or one or more individuals. Okay, so that's the law. So basically, looking at your petition, Mr. Marlin was placed on probation, deferred adjudicated probation on April 23rd of 2021. And this motion was filed October 19th of 2021. And so if we look at 1, it says a person does not request a weapon before the 61st day after the date of judgment or conviction or the order placing a person on deferred adjudication. The 61st day would be June 23rd of 2021. And he made the request of this in this motion on October 19th, 2021, which was 179 days after being placed on probation, deferred adjudicated probation. And so he doesn't meet the requirements as stated under Article 18.19D, Section 1. And there's no evidence that he was previously convicted of a Chapter 46 Penal Code violation, another unlawful carrying a weapon. There's no evidence that he is on, or that he had, or that this weapon is a prohibited weapon. I think it was a Glock.
Yes, that's correct, John.
And there's no evidence that this offense was committed on the premises of a playground, school, video arcade facility, or youth center. And we have no information in terms of his criminal history, his prior criminal history. We do know the circumstances of this offense because that's listed in the probable cause affidavit. The court is going to take judicial notice of the court's file. The probable cause affidavit is in the court's file. Yeah, so I don't think it says shall order. Okay, that means it's not discretionary. It's mandatory. So the court does not have authority to order this gun return if he does not meet the requirements of this statute. And the court is going to follow the law. It says, however, the court entering in the judgment shall order the weapon destroyed, sold, or forfeited if, and it gives these, unless one of these 5 requirements are met. That's the way I read the statute.
May I respond, Your Honor?
Yes.
I guess I'm reading it differently. And I mean, we clearly don't make the 61-day cutoff, but Mr. Marlin has not previously been convicted under Chapter 46 of the Penal Code.
But if you look at Section 4, that's an or. It doesn't say and, it's or. If he meets one of those if he does not request it within the 61 days, or if he has, if he's previously convicted of an unlawfully carrying a weapon, or if he has, or if it's a prohibited weapon, or it was the offense occurred on the premises of a playground, school, video game facility, or youth center, or the court determines based on the prior criminal history or the circumstances surrounding it, be posed a threat. So it's if he meets any one of these, the court don't the way I read the statute, then the court shall order that this weapon be destroyed, sold, or forfeited.
Judge, I'm just, could we have one moment, Your Honor?
Yes.
Thank you.
Okay, we'll be in recess.
Thank you.